Hello, welcome again to Immigration News and Views. My name is David Nachman and I'm one of the managing attorneys at the Nachman Fawani Zimochek Law Group. We have offices here in northern New Jersey. We also have an office located in Midtown Manhattan. We also have an office, an affiliated office in Mumbai, India, located in Bandra, near the Bandra Kula complex, which is where the consulate is. And we also have affiliated offices where our clients are able to meet with our Canadian lawyers in Montreal and in Toronto. So today I want to talk to you about investor visas to the United States. And we've talked a little bit about entrepreneur investments and entrepreneur programs here in the United States for immigration. And one of the things that we've highlighted for you is that when Alex Mayorkas was in charge of the USCIS, he took a great step forward in ensuring that there's a special program online for enabling entrepreneurs to be able to get visas in the United States and to be able to add to our economy by bringing foreign investment to the United States or by building jobs in the United States for U.S. workers. So there are a couple of different ways in which this can be done, and in another video we'll highlight the entrepreneur program with regard to H-1Bs, TNs, and in some of the other non-immigrant areas. But the one I'd like to focus on today is what's called the L-1A. The L-1A is the intra-company transfer. And oftentimes we get inquiries from clients who call us up and they are asking us about EB-5, the EB-5 investor visa, which is also referred to as the entrepreneur visa. Now there are several different types of EB-5 programs which I want to make you aware of. And now what we're talking about when we talk about EB-5 is the green card through an investment in the United States. So there are several different types of these. The first one, which is probably the most common one, is where an individual is making an investment of $1 million in the United States. They're developing 10 jobs for U.S. workers, and they're doing it in a non-employment deficient area. So what it is that an individual is essentially making an investment of their own funds. These funds have to be clean funds, that they're not obtained from any type of an illegal activity. They're making this investment in the United States, generating jobs for 10 U.S. workers, taking an active role in that business, and that is the EB-5. So that's one type of EB-5 program that's available. The second EB-5 program which is available is one where rather than to make a $1 million investment, the individual only needs to make a $500,000 investment. But that $500,000 investment needs to be made in an area which doesn't necessarily, it can be an economically, we call it like an economically underserved area. So these areas are designated by the state departments of labor throughout the country. Now, the individual, so it would require a little bit of research to figure out which areas they are. In New Jersey, there are certain counties and certain cities which qualify for this $500,000 investment to allow the green card to be granted to an individual investor and the members of his family. But the same criteria apply, that there have to be 10 jobs for U.S. workers, although the 10 jobs don't have to be immediate. They also have to take an active role in the business. The third type of EB-5 program, which many people are aware of, and probably most aware of because it's been highlighted in the media through articles that have been done, for example, about JPEAK, which is one of the regional centers, is the regional center investment. The regional center investment in general requires about $500,000 investment, but the individual doesn't have to be actively involved in the business. They put $500,000 into a qualified regional center, and then that money is used by the regional center for whatever investment it might be. There are some regional centers that are construction business regional centers. There are some that are hospitality. There are some regional centers that are into making wine. So there are a whole bunch of different regional centers, and those regional centers can be accessed on the web. And there are various websites that provide access to lists of these types of regional centers. So EB-5 is one way in which an individual wants to come to the United States and invest money can be an investor and can immigrate to the United States. Another way that individuals can immigrate to the United States, and especially if they're businessmen or women from abroad, oftentimes they have a thriving business in their home country, and so what we'll do is we will of course offer up the opportunity for them to do an EB-5, but the problem with the EB-5 is it ties up your money for a long time, and sometimes, unfortunately, it's not in your own business if you're going the route of a regional center. So what we oftentimes will try to do is we'll try to provide a different alternative, and one which we call the L-1A conversion to E1-3 multinational executive. So let me explain how that type of a scenario works. First of all, the way it would work is that a foreign national who is in charge of a thriving business abroad is able to come to the United States and open up, usually it's an LLC, although they might open up an Inc., or they might open up an LTD. However, generally speaking, it's an LLC. That LLC is opened up as a subsidiary, although it could be an affiliate, it could be a branch office, of the foreign organization. And then what they do is they would transfer to the United States as a manager executive, an intercompany transfer, coming to the United States to establish that subsidiary here. Now, it's called, if you're looking at what the scenario is called, it's called a new company L-1A. And it's very important that you have the appropriate documentation when you do a new company L-1A to be able to show that the organization is bona fide, it's being set up in the United States, and that the affiliation or the ownership of equity is clear between the foreign organization and the U.S. organization. What we generally recommend, to keep it nice and precise for the officers of the USCIS, is that when you establish a subsidiary here in the United States, it's best to have 100% of the foreign organization own the U.S. organization. And that, of course, is very important for you as the potential investor or manager who's coming to the United States to talk to your tax advisors to try to figure out what the tax impact is going to be for setting up an organization of that ilk. Because what you don't want to do is find out later on that you're going to get a heavy tax bill as a result of having set up a relationship like that. So obviously one of the things that drives doing this type of a scenario is whether or not it's going to be a good or a bad tax impact for you. So once this organization is in place, where you have the foreign corporation that owns 100% of the U.S. LLC, and by the way, that LLC can be in any state, of course, in the country. Once that is set up, then the individual can apply to the USCIS for an L-1A, a new company L-1A. Now the difference between the L-1As that we've described in prior videos, where you get an initial 3-year grant of stay in the United States, for this type of an L-1A, the new company L-1A, you only have 1 year. And then what you do is you go back after that 1 year, and you then can extend that L-1A for an additional 2 years, with the idea that you can possibly get a total of 7 years of stay in the United States in L-1A status. Of course, once the L-1A is extended, and the individual, of course, is hopefully doing business, has built up that U.S. subsidiary, has a lot of employees, has a lot of transactions through that U.S. subsidiary, then, of course, the idea would be to convert that L-1A into an E1-3, which is a green card for a multinational executive. And that's, of course, a procedure which we can discuss in a later video for you, so that you understand what would be involved in doing a case like that. But the idea here is to let you know that positing your money in a regional center for the sole purpose of immigrating to the United States may not in all cases be the best solution for individuals. You have to consider whether or not you, as a business person, want to look at the possibility of continuing your business here in the United States and establishing a subsidiary, an affiliate, or a branch office of your foreign organization here in the United States. It's important also for you to note that if you transfer in on the L-1A, your family members will receive derivative L-1A visas, and your spouse will automatically receive work authorization in the United States, which would allow him or her to go to work for either your subsidiary here in the United States or any other organization that he or she chooses. Thank you very much for being with us today. We appreciate your patience. I hope that I've made some of the alternatives to the EB-5 classification clear to you. If you have any questions at all about immigrating to the United States based upon the entrepreneur program or based upon some other business methodology, please give the attorneys in our office a call. We'd be more than happy to help you. Thanks very much for tuning in. Bye now.